Hi everybody, welcome to another video from Seller Legal. Wanted to talk to you about something that comes up regularly in our practice, which is the concept of COBRA, which deals with continuing your medical insurance after your employment has ended. And it's a topic that not many employment lawyers are comfortable or familiar with, but it's an area of the law that gets frequently violated by employers, causing significant consequences to former employees. So let me give you an example of a client who we're currently assisting. He worked for a company for a couple of years. He regularly paid into his insurance plan through the employer, always made his premium payments. Turns out the employer was making a mistake and didn't properly disclose the payments to the insurance company. And unbeknownst to the employee, his insurance was canceled. Well, the employee gave his medical card to the hospital when he went in for knee surgery, had complications. Long story short, he starts getting bills for close to $250,000, and his insurance claims are being denied. And guess what? He's now stuck holding the bag for close to $250,000. So, what happened? Let me tell you what happened. Under the law, if an employee is separated or there's what's called a qualifying event where the employee can no longer work, the employer and the insurance plan or provider have a requirement to notify the employee of their continuing insurance rights. So here's what has to happen. Let's say you're fired, or let's say you're no longer able to work, and notify the employer. That's what's called the qualifying event. From there, your employer has 30 days from that date to notify the plan administrator, meaning the insurance company, that there's a qualifying event, you can no longer work, or you've been terminated, okay? From there, the insurance plan has to notify you within 15 days of your COBRA rights. And if you've ever been fired, you've received a letter in the mail saying, hey, you can continue your COBRA policy, which means your insurance benefits can continue, although it's gonna be more expensive for you to do, obviously, okay? If the employer doesn't notify the plan administrator within 30 days, they have violated the law. And if the plan administrator doesn't notify you within 15 days of that 30 days, they have violated the law. If either of those happen and your insurance claims get denied, there is a valid claim for COBRA benefits, reinstatement, and payment of all of your medical bills, as well as penalties to the employer. So in this current situation, we have filed suit on behalf of the employee because in that instance, the employer did not give a 30-day notice to the plan provider. The plan provider never gave notice to our client of his COBRA rights. And because of all of that, he's now stuck on the hook for $250,000. The good news is the law also allows us to recover our attorney's fees on top of what we recover in a COBRA action. So long story short here, if you're part of your employer's benefits plan and you stop working or get fired, they have to notify you of your COBRA rights within 45 days total. That's 30 from the employer, 15 from the plan provider. If you don't get notice of your COBRA rights within 45 days, there is a violation and your insurance claims moving forward may not be protected. Keep an eye on that. Of course, guys, any questions, comments, richard@floridaovertimelawyer.com. If you have any questions about your COBRA coverage or anything else going on in the workplace, we're here for you. Fall's on the way, late September day. Hope everybody's doing well. We'll catch up soon. Thanks.